Recorded live.
Good evening, everybody. This is Matthew. I'm your moderator for the Free Americans conference call. This is our regularly scheduled Wednesday night call at 8 p.m. Eastern Time. And before we get started tonight, I'm going to read the Notice Acknowledgement Agreement. This show and our document is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure. It is not a substitute for legal advice and or guidance by a licensed attorney. This private show and our documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing the show and or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or short recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. And with that said, I turn it over to Christian.
Okay, thanks, Matt.
You're welcome.
Again, we're starting on section 2 on page, lost the page, 304 in the book on Lewin's on the Practical Treatise on Trust. Under section 2, the properties and devolution of the legal estate and the trustee. This branch of our subject we propose to consider first with reference to the common law and secondly with reference to the construction of particular statutes. First, of the legal estate at common law. Number 1, the legal estate at common law. It may be stated as a general rule that the legal estate in the hands of the trustee has at common law precisely the same properties and incidents as if the trustee were the usufructuary or owner of dower, courtesy. If real estate is put in trust, it is subject at the law of the hands of the trustee to courtesy and dower. And in the case of copyhold and free bench, and until the late act, the trust estate was enabled to forfeiture and the decease of the trustee. If there was no heir, it fell by its cheat to the Lord. But by 13 and 14 Victoria, section 60, and subsections 15 and 46, substituted from 4 and 5 W4C23, the legal estate of the trust property was protected from forfeiture and its cheat. And by another act, it was enacted that, quote, upon the death of the bearer, trustee, intestate as to any corporeal or incorporeal hereditament of which such trustee was seized in fee simple, such hereditament should vest, like a chattel real, and the legal personal representative from time to time of such trustee, unquote. But the act was not to apply to lands registered under the same act. Next section, under 44 and 45, Victoria, section 41, the legal estate devolves to personal representatives. This enactment is, however, in the case of deaths occurring after the 31st of December, 1881, repealed and it is supplied by a provision that where an estate or interest is of an inheritance or limited to the heirs as special occupant, in any testaments or hereditamentos, corporeal or incorporeal, is vested on any trust or by way of mortgage, and in any person solely, and the same shall, on his death, notwithstanding any testamentary disposition, devolve to and become vested in his personal representatives or representative from time to time, in the like manner as if the same were a chattel real vesting in them or him, and accordingly all like powers, for one only of several joint personal representatives, as well as for a single personal representative, and for all personal representatives together to dispose of the otherwise deal with the same, shall belong to the deceased personal representatives or representative from time to time, with all the like incidents, but subject to all the like rights, equities, and obligations, as if the same were chattel real vesting in them or him, And for the purpose of this section, the personal representatives of the time being of the deceased shall be in law, his heirs, and assigns within the meaning of all trusts and powers. 2. Trust chattels subject to forfeiture. So chattels real and personal held upon trust were forfeitable until the late act, which extends to personal as well as real estate, for the offense of the trustee. But in the case of two joint trustees, a moiety only was forfeited, and the king and the other trustees were tenants in common. Next section, devolve on ex-executor. On the decease of the trustee, the chattel, as part of the personal estate at law, devolves on his executor or administrator. And if the executor die after probate, having appointed an executor, the chattel becomes vested in that executor. 3. Renunciation by one executor. Until the late act of the executor had renounced probate, the renunciation, though prima facie absolute, might be retracted at any time before the new administration was granted. Hence, where two executors were named and one renounced and the acting executor died, having appointed executors, but predeceased his co-executor, it was necessary to take out letters of administration to the original testator for the acting executor not being the survivor until did not transmit the interest, and the renouncing executor declined to act. But now by 20 and 21 Victoria, Section 77, subsection 79, where an executor renounces probate, the rights of such executor are made to cease, and the representatives to the testator in the administration of the effects without further renunciation go devolve and are committed as if such person had not been appointed executor. But the act does not apply to the case of person who renounced before the act came into operation. And if he renounced before the act, any second renunciation after the act for the purpose of bringing himself within the ultravirus and negatory, and if a disclaimer or renunciation by answer in chancery was held not to operate as a renunciation within the act, and the renunciation is not complete until it has been entered and recorded in the proper office. But it has not been settled that the executor, after renouncing, may not on proper grounds retract his renunciation. By 21 and 22 Victoria, Section 95, subsection 22, whenever an executor survives the testator, but dies without having taken probate, or is cited to take probate and does not appear, the right of the person is in the respect of the executorship shall wholly cease, and the representation to the testator and the administration of his effects shall and may, without any further renunciation, go, devolve, and be committed in like manner as if such person had not been appointed executor. 4. Where term and trustee requires a prerogative probate. If the lands comprised in the trust terms were substituted in effect diocese from that in the trustee was domiciled, it seems that previously to 20 and 21 Victoria, Section 77, which created the court of probate, a prerogative probate or limited administration was necessary before the term could have been legally transferred. Administration limited to trust property. Next section. If there be a difficulty in the way of probate or grant of general letters of administration, special letters of administration limited to the trust property may be taken out. Special letters of administration limited to the trust property may be taken out. 5. Where a chattel may be taken in execution of the debt from the trustee, a chattel found by the sheriff in and possession of the debtor is prima facie the debtor's own property, and as such is liable to be taken in execution for his debt. But if the sheriff, knowing the chattel to be bound by a clear trust for another, were to sell it for the debt of the trustee, it would be a tortuous act in him, and the creditor who received the proceeds would be accountable as a trustee, and the city key trust may, upon seizure of the sheriff, establish his equitable title at law upon an interpleader summons. I want to read that section again here. Whether a chattel may be taken in execution for the debt of a trustee. Section 5. A chattel found by the sheriff in the possession of the debtor is prima facie the debtor's own property, and as such is liable to be taken in execution for his debt, But if the sheriff, knowing the chattel to be bound by a clear trust for another, were to sell it for the debt of the trustee, it would be a tortuous act in him, and the creditor who received the proceeds would be accountable as trustee. And the City Key Trust may, upon seizure by the sheriff, establish his equitable title at law upon an interpleader summons. On the other hand, if a person be the City Key Trust of an equitable chattel, the sheriff may take an execution for the debt of the City Key Trust. And this is so even when the City Key Trust claims under an agreement for valuable consideration for settlement of after acquired property. But such an agreement is a roving one and executory, and does not give the City Key Trust the privilege of the specific purchaser until actual possession of the chattel under the agreement, and in the interest of the City Key Trust may therefore be defeated by a judgment creditor of a settler who takes out execution before actual possession by the City Key Trust. Next, Section 6. The common law requires assets in the hands of an executor to be trust property. Assets in the hand of an executor are regarded as a species of trust property, even by the common law, which in respect to them is engrafted upon itself a quasi-equitable jurisdiction, and as if an executress marry, she may by will, without the consent of her husband, appoint an executor in whom the assets will vest, and who will thus become the executor of the original testator. And though the husband during the coverture has power to dispose of the assets in the course of administration, he will not be entitled to them in his marital right by survivorship, and if the wife survive, she is liable for the divestivite committed by her husband, nor can the assets be taken in execution for the debt of the executor unless under such special circumstances as give the creditors of the executor a better equity than the creditors of the testator, as where the executor has been allowed to retain the assets for a considerable time and deal with them as his absolute property. But if possession by the executor of the assets for a long time, if in accordance with the trust, will not raise such an equity, and if under the old law as to forfeiture, the executor committed felony or treason, the assets were exempted from forfeiture to the crown, and if the executor die intestate instead of vesting in his administrator, they vest in the administrator de bonus non of the testator. Section 7. Attachment. Attachment by the custom of the City of London does not apply to debts where the beneficial interest is vested in a person other than the defendant sued in the Lord Mayor's court, and the garnishee has notice of the trust. 8. Trustee may deal with the trust estate by act inter vivos. A trust estate, whether real or personal, may at law be conveyed, assigned, or encumbered by the trustee like a beneficial estate, and if there be a co-trustee, each may exercise the like powers of ownership over his own portion, and if lands be vested in trustee as joint tenants, each may at law receive the rents, and each may at law serve the joint tenancy by a conveyance of his share. And if the trust estate be stock, each may receive the dividends without any authority from the co-trustee. Next section, general words. But in the dealings with the trust estate, the court has regarded as to the trust and will not construe general words to pass the trust estate where the assurance, if so construed, would amount to a breach of trust. 9. May devise or bequeath it. As a trustee may at law dispose of property in his lifetime, so he may devise or bequeath it at his death. But in the case of a trustee or mortgagee dying after the 31st December 1881, any estate or interest of inheritance or limited to the heir as special occupant in any tenements and hereditaments, corporeal or incorporeal, will, notwithstanding any testamentary disposition, devolve on the personal representative of the trustee or mortgagee in the same manner as if it were a chattel real. It has been therefore useless for a trustee or a mortgagee to devise the property of the above description, and the title to such property must be made through the legal personal representative. But a trust estate will not in the case pass by the same words in the will as a beneficial ownership would, for whenever the estate does not pass by operation of law solely, but through the medium of the intention, it becomes necessary in order to ascertain the effect of the instrument to take into consideration the particular circumstances of the trust. In what cases the trust estate will pass by the general devise, number 10. Where a trust estate shall pass inclusively in a general devise, it is a question that has been frequently under discussion, and notwithstanding the charge in the law introduced by the Conveyancing and Law of Property Act, 1881, is still a question of importance where the death of the trustee occurred prior to the commencement of that act. The rule as ordinarily established was that a general expression would carry a dry trust estate, but afterwards there were some misgivings upon the subject, and the court had acceded to the position that general words would not pass trust estate unless there appeared a positive intention that they were so passed. The question was reconsidered before Lord Eldon when the result of the cases, after a careful examination of them, was declared to be that where the will contained words large enough and there was no expression authoring or narrowing construction or any such disposition of estate as was unlikely a testator would make a property of his own, as complicated by limitations or any purpose inconsistent with a probate intention to devise as to let it descend, and in such a case the trust estate would pass. A residuary devised to trustees upon trust to sell past the legal estate in a property which the testator has in his lifetime contracted to sell. Next, section 11, change or charge of debts, and will exclude the trust estate. A charge of debts, legacies, annuities, and a fortiori in direction to sell is considered a sufficient indication of an intention not to include a mere trust estate, as where a testator having a trust estate and also estates of his own gave and devised all his real estate, whatsoever and wheresoever, to G.T., her heirs and assigns, forever charged with £50 to his friend W. And it was held that the trust estate did not pass. And so where the testator gave, devised, and bequeathed to trustee all such real estate as were then vested in him by way of a mortgage, the better to enable his said trustee to recover, get in, and receive the principal monies and interest which might be due thereon, it was ruled that the devise extended only to mortgages vested in the testator beneficially and did not pass the legal estate in a fee vested in the testator upon trust for another. 12. What expression will or will not exclude the trust estate? The expression, my real estate, will not restrict meaning to those vested in the testator beneficially, nor will a devise to A, his heirs and assigns, quote, to and for his and their own use and benefit, unquote, nor a devise to A and his heirs to be disposed of by her by will or otherwise, and she may think fit, although under the devise to a woman for her separate use, the words import a beneficial enjoyment. A dry legal estate will not pass, but a devise to a woman, her heirs and assigns for her and their own sole and absolute use, expresses only the absolute interest and does not create a separate estate. Where a residuary devise of lands to persons as tenants in common in equal shares will pass a trust estate has never been expressly decided, but a judicial opinion has been expressed and such that a devise would not pass a dry trust estate. A devise to the testator's nephews and nieces share alike as tenants in common and not as joint tenants, as the class as unascertained as the date of the will, does not pass a trust estate. And if the devise to be for A, for life, and to tail, with remainders over, a strict settlement, the trust estate will not pass. Where there is a limitation of the real estate, said Lord Eldon, in strict settlement with a vast number of limitations, contingent remainders, executory devises, powers of joinduring, leasing, and raising sums of money, it is impossible to say the intention could be to give a dry trust estate. 13. Distinction as to legal estate and mortgages. The question of whether the legal estate or mortgage in fee passes by a general devise to the will of the mortgagee stands on a different footing. The mortgagee has beneficial interest in the property as a security, a direction not always sufficiently adverted to, but which is strongly in favor of the legal estate passing to the person who has to receive the mortgage money. It is clear that the legal estate passes in general devise of the securities for money, and neither the general trust to sell and convert nor a charge of debts will prevent it from so passing. And it is conceived, with notwithstanding a former decision of the Court of Executure, that the case of a general devise and bequeath of real and personal estate charged with debts or legacies admits of no substantial distinction, but the legal estate will not pass by general devise of real estate, and if there be special trusts for sale or other limitation, and which would be inapplicable to the estate and mortgage. Next distinction, now not material. The distinction between the mortgaged estate and the trust estates has ceased, and in the case of mortgagee and trustee dying after the 31st December 1881 to be material, as in either case the power of disposing of the legal estate is now vested in the personal representatives of the mortgagee or trustee so dying. Next section, 14, powers of trustee in equity to devise the trust estate. The rule that trust estates pass under a general devise assumed that the testator, by making such a devise, did not commit a breach of trust. Otherwise, general words would not have been construed to carry the trust estate. However, it was observed in one case by the late Vice Chancellor of England that in his opinion it was not lawful for a trustee to dispose of the estate, but that he ought to permit it to descend, and that there was no material difference between the conveyance inter vivos and a devise, for the latter was nothing but a post-mortem conveyance. But Lord Langdale considered that there was a wide distinction between a conveyance in the trustee's lifetime and a devise by his will, for during his life he had a personal direction confided to him that he could not delegate, but the settlor could not have reposed any personal confidence in the trustee's heir, nor it could not be known for beforehand in such an heir would be, and that if the estate were allowed to descend, it might become vested in a married woman, infants, or bankrupts, or persons out of the jurisdiction, and he could not therefore hold it to the breach of the trust to transmit the estate by will to trustworthy devisees. But the question is, since the recent alteration of the law under which the trust estate devolves as a chattel real ceased to be one of particular interest. 15. Whether a devisee can execute the trust. How far a devisee of the trust estate can execute the trust will depend on the intention of the settlor, to be collected from the terms in which the instrument is expressed. Thus, real or personal estate may be so vested in A that A alone shall personally execute the trust, and in such a case, the heir or executor of A, though he took the legal estate, could not act as trustee, and a fortiori in such a case as a devisee might, though made the depositary of the legal estate, would have no authority to execute the trust. It was laid down in the former editions of this work that if a settler vested an estate in A upon trust that A and his heirs should sell, and A devised the estate, neither the heirs nor the devisee could sell, not the heir, for as regards this estate, the descent had been intercepted, and there was no heir, and not the devisee, for he was not the person for whom the execution of the trust was committed. This proposition was founded upon Cook versus Crawford and subsequent cases, and in the recent case of Osborne versus Rowlett, and the late M.R., after an elaborate discussion of the cases, came to the conclusion that Cook versus Crawford was wrongly decided, and he held that where a real estate was devised to trustees and their heirs in trust for sale, the trust was annexed to the estate, and that as the surviving trustee might have lawfully devised the trust estate, the devisee might execute the trust, and he expressly overruled Cook versus Crawford. In a subsequent case, however, before the Court of Appeal, in which the precise point did not arise, L.J.J. James and Bagley expressed a doubt whether Osborne to Rowlett was rightly decided, and the question must be, in the present state of the authorities, considered as an open one. It has been observed that M.R. justifies his decision on the ground that the decision in Coke versus Crawford was, in his opinion, based on the assumed principle that the trustee, unless authorized to do so, could not lawfully devise the trust estate, and that as the principle has been overruled by subsequent cases, Cook versus Crawford has ceased to be a binding authority, but it is submitted that the real ground for the decision in Cook versus Crawford was that the authority to execute the trust must be directly given by the original settlor or testator, and that the surviving trustee, by devising the estate to a person not so authorized, did not entitle the devisee to execute the trust. It has been submitted that the principle has not been called in question. However, exceptions have been taken to the observations in Cook versus Crawford as to the duty of the trustee to let the trust estate descend, and that, however strong the argument might be, if the matters were one of first impression in favor of holding that the trust may be executed by any person to whom the estate comes consistently with the provision of the original settlement or will, it is too late now to overrule Cook versus Crawford and the subsequent cases and to introduce a new principle. And in a subsequent case in Ireland, where a testator appointed A and B executors and trustees of her will, that is devised real estate to them upon trust, that they or the survivor should pay the rents to A for his life, and after his death sell the estate, it was held that the executors of B, who survived A, could not make a title, notwithstanding the 30th section of the Conveyancing and Law of Property Act, 1881. 16. Regarding Burt's estate. In another case where leaseholds were assigned to two trustees, their executors and administrators upon trust, and the surviving trustee devised the leaseholds to A and B upon the same trust, and appointed A, B, and C executors on a petition by A and B to the court to have the trust fund the proceeds of the leaseholds paid out to them. Vice Chancellor Kindersley refused, observing that the surviving trustee had no authority to bequeath the execution of the trust, but could only pass the legal estate. The petition was then amended by joining C as to co-petitioner, so that the petition was now that the legatees and also of the executors, but the Vice Chancellor still refused on the ground that the testator had himself declared that his executors as such should not be the trustees, and therefore, since by the bequeath he had taken the legal estate from those who ought to have been trustees, but there must be an appointment of new trustees. 17, where the trust is confined to the trustee as his assigns, but as most frequently happens, that the estate is vested in A upon trust that A, his heirs, executors, administrators, and assigns shall hold upon the trust. The question is whether a devisee of A, as failing under the description of assigns, not only take the estate but also execute the trust. In Tilley versus Wolfensum, where the settlement contained no power of appointment of a new trustee, it was held that a conveyance in the lifetime of the trustee to a stranger would not have been a breach of trust. The word assign could only mean a devisee taking under a post-mortem conveyance, and when the personal confidence in the trustee necessarily ceased, and consequently that the devisees had not only the legal estate, but were properly trustees within the scope of the settler's intention. 18. Tilley versus Wolstenholme doubted. This case seems to have raised some scruple in the mind of V.C. after L.J. Knight Bruce, for he observed that what he should have done in Tilley versus Wolstenholme had come before him, he need not say, nor was he sure. And the reasoning upon Lord Langsdale proceeded not to quite conclusive, for the word assigns does not necessarily imply a device, but it would be satisfied by holding it to refer to a tenant by courtesy or dowers, who would be assigns in law. However, the case was referred to without disprobation that Lord Cottingham, and was approved by V.C. Stewart. 19. Hall versus May. In Hall versus May, V.C. Wood went further and held that under a trust containing the words assigns and also a power to appoint new trustees, the devisee could make a title, and it was concluded that the words assigns would not have been entitled to trustee to transfer the trust by act inter vivos, and it could not be disputed that as the instrument contained a power of appointment of new trustees, the assigns introduced by virtue of the power to give a meaning of the words assign without having recourse to the devise. It was therefore necessary to lay down a broader principle that the act upon Tilley versus Wolstenholme and the doctrines upon which the Vice Chancellor proceeded appear to have been substantially these: that a settlor must have intended to provide a permanent machinery for the execution of the trust, that he would not have reposed any personal confidence in the trustee's heirs who was unknown and could not be ascertained beforehand, and that the settlor must have contemplated the possibility that on the death of the trustee the heir might be an infant or lunatic or bankrupt or insolvent, and so either incapable or unfit to discharge the office, that it might therefore be reasonably inferred that the settlor meant by confiding the trust to the trustees, his heirs and assigns, to give the trustee discretionary power of preventing these inconveniences by vesting the estate in a divisee, and that the circumstances that the settlor had given the surviving trustee a power of appointing new trustees by deed rather favored the view that he also intended, using the words assigns, to confer on the trustee that he must devise the trust estate. The court also actuated by the feeling that the many titles must have been accepted upon the footing of an enlarged construction. The decision was perhaps a bold one, but having been made so is not likely to be disturbed. 20. Sale by heir, where a testator devised freeholds and copyholds estates to trustees and their heirs upon trust that they, his said trustees or the trustees or trustees for the time being, that his will should sell the estate, it was held that the copyhold heir of the surviving trustee to whom the estates had descended could execute the trust. 21. 44 and 45 Victoria, Section 41, where under the 30th section of the Conveyancing and Law Property Act of 1881, trust or mortgage estates become vested in the personal representatives of trustee or mortgagee. They are, for the purpose of Section 2, be deemed at law as heirs and assigns within the meaning of all trusts and powers. The wording of these sections is not clear, but it is conceived that it enables the personal representatives to execute the trust and powers which were originally reposed in the trustee, his heirs, and assigns, and they may therefore sell in any case where there was a trust for sale or power of the sale for the heirs and assigns of the living surviving trustee. 22. An estate contracted to be sold with be included in the general devise. A survivor after the contract for sale before the completion of it is a trustee for the purchaser sub modo only, and the estate will pass by a general devise in his will, where it would not have been included had the testator been a mere and express trustee. Next, personal representatives can convey, but by the Conveyancing and Law of Property Act 1881, Section 4, it is enacted that where at the death of a person there is subsiding a contract enforceable against the heir or divisee for the sale in fee simple or other freehold interest descendable to the heirs general in any lands, his personal representative shall, by virtue of the act, have power to convey the land for all the estate and interest vested in him at his death in any manner proper for giving effect to the contract. But a conveyance made under this section is not to affect the beneficial rights of any person claiming under a testamentary disposition or as heirs or next of kin of testator or intestate, and the section applies only in cases of death after the 31st of December, 1881. Next, Section 23, trustee has the privileges and burdens of the legal estate. As the dry legal estate in the hands of a trustee is subject to the statutory modifications above referenced to, affected by the operation of law, and may be disposed of by acts of the trustee precisely in the same manner as if it were vested in him beneficially, so it conveys upon him all the legal privileges and subjects him to all the legal burdens, and that the incident to the unfructory possession. Next section, trustee must bring action. Thus, the trustee can bring any action respecting the trust estate in a court of law, the city key trust, though the absolute owner in the equity, being at law regarded in the light of the stranger. So the trustee of a manor is the person to appoint the steward of it, and the trustees of an advowson to present to the church, but in either case it is mere legal right and is bound in equity to observe the direction of a city key trust. 24, trustee must prove in bankruptcy. So where a debtor to the trust estate becomes bankrupt, the trustee may prove for the debt, and that without the concurrence of the city key trust, unless it be a simple trust where A is trustee for B, absolutely, and then it rests in the discretion of the judge to require the concurrence of the city key trust, for who knows but that B may have already received the money. Next section, case of trustee a bankrupt. If the trustee himself become bankrupt, a city key trust may obtain an order to prove for the whole sum, and he will be entitled to vote at the choice of the creditor's trustee. A mere trust of a debt for a person absolutely entitled and under no disability cannot present a bankruptcy petition against the debtor without the concurrence of a city key trust, whereas a city key trust who is competent to do so might have released the debt. It might well happen that there was no real debt at all, although in a legal parlance it might be a debt. And it makes no difference whether the trustee has obtained final judgment against the debtor for the amount and has served a bankruptcy notice to the debtor under Section 4, subsection of the Bankruptcy Act of 1883. But the trustee can serve a good bankruptcy notice without the concurrence of the city key trust. 25. Trustee, if in possession of votes or coroners. The trustee and the legal proprietor had originally the right of voting for coroners, but by 58G Section 3, Section 95, Section 2, it was transferred to the city key trust in possession. This act, however, has since been repealed, and the matter now stands as it did before any legislative inference. 26, trustee's right to vote for a member of Parliament. So the trustee was the person entitled at common law to vote for a member of Parliament, but by the 71st section of 6 and 7 Victoria Section 18, it is enacted that no trustee of the lands or tenements shall in any case have a right to vote in any such election for or by reason of such trust estate therein, but that the city key trust in actual possession or in the receipt of the rents and profits thereof, though he may receive the same through the hands of the trustee, shall and may vote for the same notwithstanding such trust. And by the 5th section of 30 and 31 Victoria, Section 102, the right of voting is conferred upon persons who are seized at law or in equity the lands of the tenements of a yearly value of £5. But a person entitled to a share of the proceeds of the sale of real estate held on trust for conversion has not such an estate as will entitle him to vote. 27, trustee liable to rates. Again, trustees are liable to be rated on the property vested in them unless they are trustees exclusively for public purposes without any profit to themselves or a particular class as trustees for courthouses, prisons, and the like. 28, trustee pays the fine on admission to copyholds. The trustee of a copyhold must pay a fine on his admission, but as the fine follows the admission, the lord cannot refuse admission until the fine is paid. And on the decease of the trustee, a harlot becomes due to the lord, and where the trustee died intestate and the customary heirs before administration devised the estate, the lord is held to be entitled to a double fine on the admission of the divisee, and is also the admission of the divisor. But where the trustee died intestate, and the court under the Trustees Act appointed a new trustee in place of the deceased trustee, and the lord demanded 2 fines, one for the admission of customary heir of the old trustee, and the other for the admission of the new trustee, it was held that he could claim but 1 fine, viz. For the admission of the new trustee, and where 2 or more trustees have been admitted jointly, on the decease of one, neither fine nor harlot is due. Not a fine for admission, because joint tenants being seized per tout, and the estate is vested upon the survivors or survivor of the original grant, and not the harlot. Because, however many in the numbers of the trustees may be, they all form but one tenant to the Lord, and therefore no harlot is demandable until the death of the longest liver. Now, on the death of the trustee of copyholders, they vest in his personal representative, who must pay the ordinary fines on their admission. If a copyhold be devised to trustees for 500 years on certain trusts, with a remainder to A.B. in fee, and the Lord admits A.B. not as remainder man, but as a present tenant, and upon payment of a full fine, the Lord has a perfect tenant, and cannot compel the tremors to be admitted. The court, in this case, diverted on to several points of practical importance, which are worth noticing. Thus, number one, it is commonly said that the admission is void, except for as it follows the uses of the surrender or the will, but the court held that the excesses of the admission is void only as against the parties interested, and that the Lord may be estopped by his own act. And two, where the tremors have been admitted, the Lord may require the admission of the executor of the last survivor, for the Lord is entitled to the tenant or to possession. And three, the admission of the tenant for the life or for years is constructive admission of the remainder man, but such an admission does not disentitle the Lord to the call for a subsequent admission of the remainder man's, where the custom of the manor gives the Lord a fine in respect of the remainder. And four, the Lord is not bound to admit a remainder man, but if he do admit him as such remainder man, although this admission may be constructive admission of the particular estate, the Lord may afterwards require the tenant for life or years to be admitted for the purposes of a new fine. Next, principles on which the fine is assured. Where a number of trustees are admitted as the joint owners of the trust estate, the fine is to be assessed upon the following principle. For the first life is to be allowed the fine usually paid on the admission of the single tenant. For the second life, 1/2 the sum taken for the first, and for the third, 1/2 the sum taken for the second. The result of which will be that, however the great the number of the trustees admitted, the amount of the whole fine will never be double that paid upon the first life, and on every change of trustees from the same fine as demandable, even where some of the surrenderees are the survivors of the old trustees, for they take the new estate, and in order to avoid these erroneous fines where the estate devolves on several trustees, all the trustees but one may disclaim or release to that one, who can then be admitted, and then the Lord can claim only a single fine. But there may have been a risk in some adopting this course otherwise than with the sanction of the court, since that to vest the legal estate in one trustee alone must be, in strictest, be viewed as a breach of trust, and the expected pecuniary advantage might, by the early death of the trustee who is admitted in the lifetime of his co-trustees, to be turned into a loss, and then the trustees might be held liable for the determinant to the trust estate, the detriment to the trust estate. The last contingency might be guarded against by an insurance affected either in the annual premium or for the gross sum payable in advance. But besides this, where discretionary powers are annexed to the trusteeship, the severance of the estates from the ordinary devolution of the trust might affect the powers, as if a power of sale be given to the heirs of the survivor and A is admitted and B survives, can the heir or the legal personal representatives of B sell? Disclaimer to avoid a fine. Next, where a copyholder has been surrendered to several trustees, there can be no disclaimer by one trustee for the purpose of vesting the entire estate in the co-trustees, where that one trustee, by having acted as owner, has virtually accepted the estate, and where a testator devised to 3 trustees whom he appointed executors, the one disclaimed and the other 2 proved the will, but wishing to escape the double fine, put forward the heir to be admitted as the persons upon whom the estate descended until the divisees were admitted. It was held that the Lord was justified in refusing to admit the heir, and the court, in the exercise of its discretionary power, would not issue a mandamus to compel him. But in the same case, the Lord having made the unusual proclamation that the heirs having tendered himself for admission, and the Lord having refused to admit him on the ground that the estate was in the devisees, who refused to come in, it was ruled that as the devisees had no title until admittance, and the estate descended to the heir, the Lord was not justified in seizing for want of a tenant. 29. Reimbursement. Though the manorial burdens in the respect of the copyholds fall upon the trustee personally at law, he is, of course, entitled in equity to reimburse himself the expenditure out of the trust estate. 30. Trustee of leaseholds. The trustee of a leasehold estate is liable upon the covenants of the lease just as if he were the real owner, but the trust estate must indemnify him in equity. It is the duty of the trustee of leaseholds property to keep it free from the risk of forfeiture, and for that purpose he is entitled to have the covenants of the lease performed out of the rents of the property, and is not bound to be satisfied with an indemnity against the consequences of breach for the covenants. And where a tenant for life of leaseholds, houses have been allowed by the tenants to receive the rents and profits, the houses had not been kept in a proper state of repair, the court, at the instance of one trustee, appointed a receiver. 31. If trustee trade in that character, he is amenable to the bankruptcy laws. If a trustee carry on a trade in due execution of his trust, he makes himself amenable to the operation of the bankruptcy law in the same manner as if he had traded on his own account, and the debts contracted by him in such trade are not debts of the testator, but his own debts, and if his decease, his lands, to those of the trader, were liable under Sir Samuel Romilly's Act to the discharge of simple contract debts, and now by 3 and 4 W4, subsection 104, the lands of all persons, traders, and otherwise are liable for the simple contract debts, and by 32 and 33 Victoria, section 46, simple contract debts are payable per passe, pari passu, with specialty debts, But an executor carrying on a business in pursuance of the directions of a will is entitled to an indemnified out of the estate as against all persons claiming under the will, though not as against creditors who claim paramount to the will. 32. Shares in companies. If trustees be holders of shares in a company, their liabilities are the same as if they were the beneficial owners, though the fact their trusteeship be noticed in the company's books. Secondly, if the legal estate and the trustee, with reference to the construction of the particular statutes. Number 1, how the legal estate is affected by the bankruptcy of trustee. By the Bankruptcy Act of 1883, it is enacted that all such property may belong to or vested in the bankrupt at the commencement of the bankruptcy, or may be acquired by or devolved on him before his discharge, shall immediately, on the debtor being adjudged bankrupt, vest in the trustee. And until the trustee is appointed, the official receiver is to be the trustee for the purposes of the Act. Number 2, assignees take different from heirs and executors. The operation of the Bankruptcy Act was thus commenced upon Lord Chief Justice Willies. The assignees under the commissions of the bankruptcy are not to be considered as general assignees of all the real and personal estate of which the bankrupt was seized and possessed, as heirs and executors are in the estate of their ancestors and testators, for nothing vests in the assignee, even at law, but such real and personal estate of the bankrupt in which he had the equitable as well as the legal interest, and which is to be applied to the payment of the bankrupt's debts. 3, the estate does not pass to the trustee's bankruptcy of trustee. It is clear, therefore, that the case of a bare trust, the property, whether real or personal, did not vest by bankruptcy in the assignees, even at law, and the proposition applies not only to the express trustee, but also the trustees virtue officii, as executors, administrators, factors, and by the recent Bankruptcy Act, it is expressly enacted that a bankrupt's property shall not be taken to comprise property held by the bankrupt in trust for any other person. for nor the property into which the trust estate has been converted. Where the trust estate or fund has been converted into property of different character, the new acquisition will equally be protected against the effects of the bankruptcy, for the product or substitute of the original thing must follow the nature of the thing from which it proceeds. Thus, if goods consigned to be a factor to be sold by him and reduced to money, so long as the money can be identified, as where it has been kept in a bag, the employer and not the creditors will have the benefit of that specific sum. When money has been said to have no earmark, the meaning is no more than this, that being the currency of the country, it cannot be followed when once it is passed in circulation. 5. Harris versus Truman. So where money was paid in the bank by a firm of brewers, and an agent was allowed to draw upon the account in order to provide himself with funds for purchasing barley to be malted for the brewers, and the agent bought large quantities of barley, and also, although not authorized to do so, of malt, and drew largely upon the account, but in lieu of paying for the barley and malt, misappropriated the monies in which he received and subsequently became bankrupt, it was held that the monies drawn out by the agent were impressed with a trust under which he was bound to appropriate them in the cash purchase of barley, and 2, even if the barley and the malt which remained in the time of the bankruptcy in the bankrupt's possession were brought in accordance with the authority given to the agent, and the legal property in them was not in the brewers but in the agent, he was a trustee of them for the brewers to the extent of the monies advanced by the brewers, for they were the product of the substitute for the original trust property, and as such subject to the trust. And 3, that the bankrupt or his representatives could not be allowed to set up the bankrupt's fraud and abuse the trust to defeat the title of the Sedekey trust. 6. Factor selling and taking notes. So if the factor sells the goods and takes notes and payments for the value of the notes, notwithstanding the bankruptcy, may be recovered by action from the creditor's trustee, for though the negotiable securities are said, like money, to have no earmark, the expression does not intend that such securities in the hands of a bankrupt have run into the general mass of his property and pass to his creditors, but only that the negotiable securities as circulating medium in lieu of money cannot be recovered from a person to whom they have been legally negotiated. 7. Factor selling for money payable at a future date. So if a factor sell the goods for his employer for monies payable at a future day and become bankrupt, and the creditor's trustee receives the money, he will be answerable for it to the merchant to whom the factor was employed. 8. Tortuous conversions of trust property. In other cases, the conversion has been in a breach of factor's duty. It was argued that as the principal would not have been bound to accept the property which the agent would wrongfully purchase, the court ought not to give a lien to the principal upon the tortuous acquisition, but the court said it was impossible that an abuse of trust could confer any right on the person abusing it or those claiming in privity with him. 9. Stockbroker selling. So if a trustee employs a stockbroker to sell out consols and invest the proceeds on behalf of the trust estate, the money arising from the sale is trust money and may be followed into the hands of the trustee in bankruptcy of a broker, where the money was borrowed for the purpose of purchasing a specific property which was to be mortgaged to secure the loan, and the borrower, in lieu of applying the money for the specific purpose, paid it to the bank and drew upon it. The borrower subsequently became bankrupt. It was held that the lender could follow and claim so much of the money as remained in the bank unapplied. 10. In whose name actions must be brought to recover the trust estate from the creditor's trustee. Where the legal property does not pass, any action against the creditor's trustee must be brought by the bankrupt himself, for he is the person possessed of the legal right. But in the case of a factor, an action may also be brought by the principal, for the absolute property remains with the employer, and the special property only vests in the agent. But if the bills be remitted to the factor, and made payable to him or to his order, it has been doubted whether the property does not so vest in the factor that no action of trover can be maintained by the principal. 11, where the trust estate has become amalgamated with the trustee's other property, the City Key Trust must prove for the amount. Amalgamated, that was the word. Amalgamated. If the property possessed by the bankrupt in his character of trustee has been so amalgamated with his general property they can no longer be identified, the representative of the trust has then no other remedy but to come in as a general creditor and prove the amount of the loss. But in one case, though the trust money had got into the trust general fund, it was held but under the very particular circumstances to have subsequently got out again. 12, case of bankrupt trustee having a beneficial interest. As a general rule, where the bankrupt has a substantial beneficial interest, however small, and in property legally vested in him, such property passes to the creditor's trustee, who takes as trustee for the creditors and other parties interested. It is conceived, however, that the rule could not apply to a case where a bankrupt is expressly a trustee, though he may himself have some partial beneficial interest, for his act ought not to work a prejudice to others, and as a conveyance by the bankrupt himself to a stranger would be a breach of trust. It can hardly be supposed that the bankrupt act could be construed to have a similar tortuous effect. Where the trust is constructive and equity doubtful, the court has sometimes directed the creditor's trustees to concur in conveying, and where the legal property passes, the City Key Trust may have the same relief and equity against the creditor's trustee as they would have entitled as against the bankrupt himself. 13, of trust chattels left in possession of the bankrupt trustee. By the Bankruptcy Act of 1883, it is enacted that the property of the bankrupt divisible amongst his creditors shall comprise all goods being at the commencement of the bankruptcy in the possession, order, or disposition of the bankrupt in his trade or business by the consent and permission of the true owner under such circumstances that he is reputed owner thereof. Thus, although all persons, traders or not, can now be made bankrupt, only those engaged in some trade or business come under the operation of order and disposition clause, and as so would be seen, they only as goods affected by the trade or business. The same section also provides that things in action other than debts due or growing due to the bankrupt in the course of a trade or business shall not be deemed goods within the meaning of the section. It should be observed that this section differs from the corresponding section in the Bankruptcy Act of 1869, which applied to the goods in order and disposition of the bankrupt trader, whether in his trade or business or not. But the existence of this distinction between denied by V.C. Bacon is the case under the Act. Under these sections, it has been held that shares in companies are not things in action with the acts, but that debentures of the company by which they undertake to pay a sum of money and interest and charge their undertaking the property with the payment thereof, and policies of life assurance, and the equitable interest in shares which are registered in the names of the persons are such things in action. Next section, forfeiture, where they are in possession according to the title. It has been decided under the corresponding clause in the previous Bankruptcy Act that the enactment does not apply where the possession of goods by the bankrupt can be satisfactorily accounted for by the circumstances of the title, as if the trustee be in possession of effects upon trust for payment of debts and become bankrupt, or if goods be vested in A upon trust to permit B to have the enjoyment for his life, and B becomes bankrupt while in possession under his equitable title, or if A, for valuable consideration, assigns his goods to a trustee for A's wife for her separate use, and the goods are in the house occupied by A and his wife at the time of the date of the bankruptcy, so property which belongs to the married woman for a separate use, but as to which the husband, by reason of there being no trust no other trustee is a trustee for the wife is not affected by the enactment. But if a residue be given to the trustee upon trust to sell with all convenient speed and to invest the proceeds in the purchase of an annuity for the lives of A, one of the trustees, and her children, the amount to be paid to A for the benefit of the children, and if instead of selling the trustees permit A to retain possession for a length of time, the goods are forfeited, such possession being contrary to the title. 14. Executors and administrators. The enactment does not extend to a lawful and necessary possession in aught or droit as that by executors and administrators, but there will be no exemption from the forfeiture of the executor can be proved to have dismissed the character of the personal representative and to have assumed that the absolute owner. 15. Factors. So goods in the possession of factors in the ordinary course of their trade are not forfeitable under this clause. 16. Reversions. The forfeiture clause affects interest in reversions as well as in possession, though such interests are contingent and the circumstances are notice was given to the trustee after the bankruptcy, but before the appointment of the assignee in bankruptcy has been held not to prevent the operation of the act. 17. Deposits. Under the old Bankruptcy Act, no forfeiture was incurred where the security for a truce in action as a policy was deposited with a banker, not by way of equitable assignment, so as to give the banker a right to receive the money, but by way of lien, so as to disable the bankrupt from receiving the money, but the case was otherwise where the depositee had right conferred upon him to receive the money, for then the truce in action was forfeited. 18. Ignorance. The clause has been held not to apply where the true owner was ignorant of his breach or ignorance of such. For if he did not know that he was a true owner, how could he have given any consent as such? And where the bankrupt held in trust for a corporation had no power to possess such property, it was ruled that the corporation, being a mere abstraction of law and incapable of action beyond the limits of its own legal powers, could not consent as true owner. 19. Where bare trustee a true owner. Whether the permission of the bare trustee can be said to be that of a true owner to prejudice of his innocent City Key Trust is a question of some difficulty. It has been decided that the City Key Trust absolutely entitled is a true owner within the meaning of the Act, but here the trustee is a mere passive depositary and can no doubt without the direction of the City Key Trust, but in the case is different, where in as a marriage settlement, a fund is vested in trustees and trust for persons under disability or not in existence. It is therefore intended that they should act on behalf of all parties as absolute proprietors. It would seem that the heir, the trustees, are regarded as the true owners, and that if the funds are left by the trustees in the order and disposition of the bankrupt, they are so left with the consent of the true owners. 20. Of judgments against the trustee. Judgments, at least so far as they affect lands for the execution against goods and chattels, is by common law derive their origin from the certain statutory enactments. Had trust been established at the time when the statutes were passed, the construction would probably have been the same as the case of the Bankruptcy Act, that is, judgments would have been held to bind those lands only which the consistory was seized beneficially, but trusts at the period of which we are speaking had not made the appearance, and therefore judgments had been held to bind lands and consistories, whether vested in him beneficiary or in the character of trustee. But of course the City Key Trust would be protected from legal processes by application to a court of equity. Garnishee Order 21. A garnishee order's nisi is attached to debt due a trustee will not be made absolute if a prima facie case be made out of the money sought to be attached is true trust money, but where money will be ordered into court to abide by the event of the inquiry, whether it be trust money or not. Section 3. What persons taking the legal estate will be bound by the trust. Page 338. We'll pick up there next time on Section 3. So let's go to some questions and answers.
All right. Folks, if you got a question, hit star 8 on your phone. You got anybody out there tonight who's got a question for Christian? Our first caller, FYAH1. You've been unmuted. Go ahead.
Hey, Christian, how you doing today? It's Marshall.
Marshall, hi. Get those phones straight around?
How are you? Say that again?
Get those phones straight around?
Not all the way completely. Working on them now. Getting a little help from a couple of the other TAs working together on it. I just had a couple of questions that I wanted to ask you. I don't really have them put together, but I'm just kind of shooting from the hip with some of this stuff. Now, last time we spoke, you had told me about the temporary restraining order, the TRO, and you told me to look for the one specifically that was speaking of an irreparable injury. And I found it, and it's from, what do you call it, from American Jurisprudence on Injunctions and Standard for Granting Relief. Is it okay to talk about the TRO right now?
Yeah, sure. Go ahead.
Okay, well, it's just a quick question I have about it. It says the moving party will suffer an irreparable injury if the relief is denied. These are the standards for granting relief. The second one is the moving party will probably prevail on the merits. Third, the balance of potential harm favors the moving party and depending on the nature of the case. And four, the public interest favors granting relief. Now, the fourth one is what I'm kind of stuck on a little bit. The public interest favors granting relief. If you could give me a little bit of clarification on that, how would the public benefit from the court's ordering some type of TRO, an injunction of some sort?
Yeah, I remember researching that out, but I really forgot what we researched out and found out about that. That one was a hard one to kind of track down, although we did come up with a reason, but it escapes me what the reason was. I think it was kind of a light one, and we had to kind of like shoot from the hip and come up with something that was pretty good and sounded reasonable. That one was a pretty tough one. I remember that one now.
Yes, I've been thinking about it all day, and I said I have to get on the phone with Christian tonight for him to explain this to me, because I was thinking, being that I am in the public with this part of this, how should I say, at-law proceeding, being that this equitable injunction of a TRO, it's an at-law procedure or, something to create a stay in the courts, jam the courts up like what you say. So I figured if I'm in the public, then I would be part of the public. Now, I don't know if I was,
Yeah, I think I remember now what it was. We kind of did the assumption that it was to the public benefit that the person not be, say, thrown out of the house because we were working on a mortgage foreclosure, because that would put the person on dire hardship, and it would affect their ability to, say, get to work, provide for their family, and they may be thrown out in the street. And nobody liked to see anybody to be homeless, and that was to the public benefit.
All right. Okay. So if they was to face that type of an irreparable harm, they would basically be dropped in society's lap to take care of this family or whoever, because they wouldn't be able to provide for themselves.
Correct. You become a burden on the public.
You become a burden to society now.
Yes.
Perfect. That sounds good to me. That's all right. Cool. I was thinking along the right lines, being that I am in the public and me facing some type of a public injury would benefit public interest for me to have some type of an injunction granted to me. Okay, so that's cool. Cleared that up for me. That was good. Now, the next thing that I wanted to ask you about was
I would also, now that I know more about what we're talking about now, I would also claim a right not to be homeless, to have the right to have property.
Wow. Right, a right not to be homeless. You know what, and I have that as part of one of my notes. I have a right of possession and a right to own personal property, so that would benefit public interest also.
Yes. Uh-huh.
Sounds good to me. Great, I was on the right track. All right, sounds good. Now, the merits now.
Oh, what did you need me for then?
No, what it really is, I just
saved yourself a nickel on the night.
I just need.
Oh, don't tell me we lost him. Marshall will have trouble with his phone.
You know, I don't see him out here anymore. I must have dropped off. Yeah, he did drop off, Christian.
Yeah,
right,
I think somebody definitely doesn't like him. The phone company just doesn't like him.
Oh. We pull up Trust Me here. Trust Me, you've been unmuted.
Hey, Christian.
Hi.
Hey, this is Steve from Minnesota. How you doing?
Okay.
Hey, it was a good conversation you had just with that guy, but real quick.
Back off your mic a little bit. You're over.
Okay. How's that?
That's better. That's better.
Okay. I'm working on this, starting this process. I've spoke to you about this a couple times. My sister as a cabin property, and the mortgage reads very interesting. It's actually I don't know if you've ever run into this before.
We're going to lose him.
Hey, do you have a phone you're calling on? You did call on.
This happened to me last time. I'm on the TalkShoe deal.
And we're getting feedback.
Okay. I'll try something else.
Okay, I'll keep my eye out for you.
Okay, thanks.
Marshall, you're back.
Christian, I'm back.
Hi, Marshall.
How you doing? All right, once again. All right, so let me make this quick. I was I moved to a different location, and I'm waiting for the people to come hook up my internet back tomorrow. So I'll be back up and running as of tomorrow. I won't be going through all of this phone cutting off stuff like I used to. But anyway, the merits, Christian, if you could give me like a layman's term explanation of the merits of a case.
Those are the facts, the material facts of the case.
Material facts. Okay, so the merits are the facts. Those are our SOIs.
Yeah, but that's where you got to be kind of careful. We're going to put in the colorable notices.
So the merits. Okay, so our SOI. Well, of course, our SOIs are our private equitable rights. Now, the merits of the case would be our colorable legal rights. Then, no.
Well, we don't want to claim any legal rights, that law. We want to claim the substantive rights under equity, which you can't bring them into the at-law side. So that's where you have to use the colorable, and that was the reasons why we were coming up with the public notices, although they weren't the actual facts. They were like the notices to let the public be able to see some kind of something there that was the mirror that reflected back into the public, or excuse me, the private, where the actual facts were.
Okay.
And that's where we bring in the in-camera hearing. So it was just colorable enough, the notices, that the public could see, and then you could have the show cause to have a hearing, in-camera hearing.
Okay. Okay, so the show cause hearing would be the in-camera hearing.
No, the good cause shown would be you've got some prima facie evidence attached, which would be the notices. But they only reflect through that you need an in-camera hearing in the private that would show the actual material facts, like the green card, that would prove delivery and.
Hello?
Yes, go ahead. Yeah.
Okay, cool. The reason why I asked you that is because reading in American jurisprudence, like I said, under injunctions, is the standards for grants and relief. One of them was the moving party would probably prevail on the merits. So it seems as if that's a requirement, but you're saying that we have to be very careful when we're dealing with the merits.
Yes, right. Mm-hmm.
All right. Okay. Now,
they just want to know, are you going to succeed? Because if you don't think you're going to succeed, then why should we spend the time?
Right. Okay. That makes sense. All right. Now, I was looking in Black's Eighth, and I came across, rights, natural rights, negative rights, positive rights. So now, a natural right, a right that is conceived as part of natural laws and is therefore thought to exist independent of rights created by government or society, such as the right to life, liberty, and property. So that sounds like equitable rights to me. Are they synonymous?
Yeah, the rights are equitable rights. Yeah.
Okay, all right, the natural rights. Okay, I just wanted to make sure about that. Now, it got me into negative rights now. A right entitling a person to have another refrain from doing an act that might harm the person entitled. Now, wouldn't something like that go inside of your pleading for a TRO?
Say that
say that again?
Yeah, say it again.
A negative right. A right entitling a person to have another refrain from doing an act that might harm the person entitled. Now,
right, that would be a restraining order.
That's what I asked you. So that would be verbiage that we would want to put into our, say, TRO or our preliminary injunctions or mandatory injunctions or what have you, right?
Yeah.
Okay, because now it took me to positive rights, a right entitling a person to have another to do some act for the benefit of the person entitled. Now, that sounds like just one big trust to me, because you have the grantor, a right entitling a person to have another do some act for the benefit of the person entitled. So that would be your trustee and your beneficiary there.
Right.
Okay, cool. I'm asking because it's just, as I'm, putting together some of the documents that I have to put together, it's just certain verbiage and, certain dictions that I would like to use to make it, recognizable by the courts and by the judges, and using their language when we're speaking to them through these documents. So I just wanted to run a couple of those by you, but that was my most important thing, to ask you about the public benefit and, how does a public interest favor grants and relief. So clarify that for me, and I think that's about it. It was a good read tonight, but I was kind of going over this in.
Did we lose him again?
Yeah, it looks like he dropped off. Next one is Dan Gretagrado. You've been unmuted. Go ahead.
Hey, good evening, Christian. This is Dan in Southern California.
Hi, Dan. Hey.
Hey, how's it going?
Okay.
All right, good to hear. I had a question for you, court-related question. I was in court yesterday helping out a lady. We were there to object to a lift of stay for a house,
Mm-hmm.
And
bankruptcy?
It was a bankruptcy court, and this was the second time we have appeared on that matter to show up to object. And there was a timely objection letter that I helped her write. It's about a 3-page letter invoking equity virtually in every paragraph and supporting it with reasons. And so we show up yesterday in bankruptcy court, and the attorney was supposed to appear on a teleconference call, and it was a no-show. I mean, didn't even have a paralegal explain why he wasn't there. It was just crickets. I mean, just wasn't there on the line whatsoever. And so I told the lady that I'm helping, we're both standing at the podium, and the judge told me I can't speak, only to her. So I told her, I said, move the court to dismiss. And she said, Your Honor, I moved this court to dismiss this motion. And the judge goes, well, I still want to hear from the attorney, and as a courtesy to him, I'm not going to dismiss. And he rescheduled the thing for like a month and a half from now. So my question is, this is twice in a row that this attorney was a no-show and flaked on a hearing or a motion. And
you could have forced the issue if you would have known. You could have gotten it dismissed. The rules would have said, "Hey, this was a no-show. You won by default."
Exactly. And she doesn't know what's going on. She's terrified of the judge, terrified of the court, and so after he gave her that explanation, she was just okay with it. And I'm sitting there writhing and fuming, And I just could not believe that this guy is going to allow this moving party chance after chance after they're not showing up and not.
Oh no, it really wasn't the judge that was allowing it. Was you were allowing the judge to go ahead and do that.
Well, exactly.
The ultimate burden comes right down to the person that's standing there and allows it, and it's not the judge, it's you.
Right. No, I definitely understood that. It's just she should have pitched an absolute fit, but. I guess my question is,
I would have said, Your Honor, if it comes down to it, either you do what the rules state that you're supposed to be doing, or else you're off the bench. I'll recuse you.
Or if he wants to enjoin himself to the case, then name him trustee right there and then. But they don't like that at all. So, but it is a bankruptcy court, and it is a trust issue. I mean, the whole bankruptcy thing is your property becomes the estate of the bankruptcy. There's a trustee. It looks like it's a full-blown equitable forum. It's an equity forum. So anyway, so I guess the question is, should we just file a written motion to dismiss into the case? Would that be?
Yeah, but then you're probably going to have it reheard then.
Okay. Good, but bankruptcy operates a little different than normal.
Yeah, no, I know.
So I'm not exactly sure what to do here, because I don't want to let it go. It's on the record that this attorney, failed to appear twice. That alone should be. I should be able to place that into the motion to dismiss as some of the points.
Yeah, I'm not in the bankruptcy rules that as much as, but yeah, there's got to be something in the bankruptcy rules that you could have stood on and made him, do the dismissal.
Right. Well, because my objection letter, stated plenty of case law that shuts MERS down. MERS doesn't have the ability to assign beneficial interest, and I evoked equity in many places, especially because all the evidence is stacked on their side. So it's inequitable to, continue on at law when we don't even have any evidence to support anything, and it's a non-judicial foreclosure, which is virtually a summary judgment, so that's not fair, So there's lots of different avenues that we can evoke equity in, and we evoked all of them wherever we could, and even quoted the equitable maxims behind those arguments. And this attorney apparently doesn't want to deal with it. And I'm not sure what to do in bankruptcy at this point to boot this case off the docket and make them start over if they want to keep pursuing this.
Yeah, it's been a while since I've been in a bankruptcy, and I forget what the rules are that I had in my head, but yeah.
I'll have to check out a book on bankruptcy procedure, see what we can do there. It'd be a shame to show up for a third time and have this thing heard again, only for the judge to swoop in at the last minute and rule in their favor. Because before we left the podium, he said something like, "I want to hear from the attorney because he still may have a case." Something to that effect. Because the bankruptcy judge looks at like three things: is there any equity in the home? Is the property required for a reorganization? And is it a Chapter 7? If it falls under those three categories, then his tentative ruling is almost always to lift the stay. So they plug your case into those three rules, and if it's yes to all three, no matter if there's fraudulent assignment, whatever, it's.
Well, that brings up some memories that I had. You mentioned the one there about is there value or equity in the house?
Right.
Is there value and equity in the house?
Yeah, human equity. Who changed the light bulbs? Who mowed the lawn? Who painted the kitchen?
Who did the valuation?
I believe in her petition, she just used whatever the current comparables are, on the internet. So it was just.
So you like went to the county and got the assessor's appraised value, what they're going to say on the taxes?
Yeah,
a certified copy of that.
Yeah, and she looked up some comps, if those are even worth anything.
I also think in bankruptcy you have to have a valuation hearing, if I remember correctly. Right. And until you have a valuation hearing and they stamp a value on it, your house has no value. Therefore, they'll lift the stay.
Okay, well that's an interesting. I know he mentioned something about ordering a BPO or a broker's price opinion or something like that on some other case.
Yeah, that's
So,
like if there's no equity in your home, what's the reason for the homeowner to even be given any rights, because they don't have any rights. There's no equity in the home, say. And then the lender would have the absolute right to come in and take the house because the house is has no value or a value equal to what is owed, and the homeowner has no value proven, no equity, so to speak. Then they'll lift the stay.
Right.
But I think in bankruptcy you must come in with a valuation hearing.
Valuation hearing.
Yeah, you might want to check that out. Make sure that that way the property is evaluated officially, and they place a value of your equitable interest in there. And then once you've proved that you've got equity in it, now you've got a right that the property is worth more than the amount owed.
Right.
And now the homeowner has an equitable right then.
Oh, I see. Okay. So that's why they keep hammering that one point, because every case that came up, he especially if no one objected or opposed, he'd say, there's no value, there's no equity in the house, it's Chapter 7, and it's not required for a reorganization. Motion granted. Next,
Yep, that's the problem.
Rubber stamping. You can sit in that courtroom and watch about 50 people lose their homes in about an hour. It's pretty amazing how fast that conveyor belt rolls.
Yeah, all because you didn't know you had to have an evaluation hearing to prove the equity in your home.
Right. Yeah, they'll let you put whatever value on there you want. It looks like you can state whatever you want. And,
yeah, but that doesn't prove it.
Sorry, what was that?
That doesn't prove it.
Right.
I mean, I could say my house is worth $10 million when it's only worth, $50,000.
Right.
It's not until some other second witness or some other record that you present as evidence that backs up what you say it's worth. Now you got two witnesses to prove a fact, which is what we're talking about with NTT. Courts work the same way.
Right.
Everything that you claim, you got to substantiate by two or more records.
It all comes back to trust, doesn't it?
Well, yeah, due process, and then you got to have a hearing, opportunity to be heard to prove your fact.
Right. Yeah. Well, court appearances have been pretty valuable. It's a good learning experience. I was just showing up to court for a while just to see what's going on. Sit there.
That would be very advisable before anybody gets into something like that, before they ever go to a hearing, that they spend a lot of time, as much as they can, and just watch what happens to others.
Yeah. I'd pack a lunch and bring my Black's Law dictionary and kind of camp out in the courtroom for 4 or 5 hours. It's pretty informative. And also I had another question on the doctrine of merger. I'm still having a hard time finding more information on it, but what do you think creates the power of that the merger of two titles? Why is that so important? What is the I might even be asking more of a spiritual question. What gives that so much power, that merger?
Well, anytime that the two titles are merged in one entity under the trust terminates.
Right. But I'm just trying to dig a little deeper and try to understand how that came into being. What is the philosophical, spiritual, esoteric, whatever you want to call it, doctrine behind this merger?
What's it based on?
Right. Because trust seems to be, a microcosm of the next step up, which would be possibly a Father, Son, and Holy Ghost, or that tripartite, that trio shows up in so many places in the world that I find it odd that it's showing up in commerce. So.
The only thing I can think of other than that, what you're talking about, is, the example of that would be, we know matter exists and we know that antimatter exists, and when you merge the two together, they cancel each other out.
Right.
And that would be under the law of nature, the nature's God. The nature's God, that would be a natural law, so.
Yeah, it's interesting stuff, and you wonder, if trust dates back to this medieval English time, and even some of the Roman era looked like they had some semblance of a trust.
Yeah, I like to look at it as, in the beginning, God created the heavens and the earth. He took nothing, split nothing in half, and created two somethings. So when you work in reverse, you put the two somethings together, you go back to nothing.
Right.
There's your merger.
So that's an interesting way to look at it. So we need to take this fractured world and reunite its polarities and recreate a oneness or a unity from all these broken pieces that are laying around. Looks like that might be an overall goal, because everything's fractured, everything's split in half.
Well, that's Romans chapter 1 and 2, the depravity of man.
Right. Yeah, I can just sit there and ponder this stuff for hours and just wonder what is this? What is this construct? This polarity, this yin yang, up down, left right. Everything's split in half. Our brains are split in half. Our bodies are split in half.
Well, God has put you through a wine press in order to make it really, you to pay attention, because He's really shown you how evil is, so that you will know by sight what God's grace is.
Right.
So He's actually teaching you His character, one of His attributes.
And as we start merging these fractured pieces, I think that's how we might get a little closer to knowing God mind, and just like you said, start learning what God is by putting these fractured pieces back together again, reunifying.
Yeah, if we can.
We can. Well, it's fun trying. At least you get a little bit of wisdom and knowledge out of it. That's worth it all, I guess.
Well, put on the armor of God and be found doing the work.
I like that one. Well, that's all I had. I just had a question on that thing. I guess what I'll probably do is I'll help her draft a motion to dismiss and file it, even if it does have to be heard again.
I think you needed an objection in there, notice of objection and opposition to what happened. That way you got on the record in case you wanted to go to an appeal or something.
Oh, gotcha. So notice of ejection.
Yeah, notice of objection and opposition.
Okay.
That's what I would do.
Okay. I will do that. Well, great, Christian. Thanks for your help. Appreciate it.
Okay, Dan. Thank you.
All right. We got Marshall back.
Okay.
Marshall, are you back?
I'm back.
Back for good this time?
Got another question.
All right.
My Skype will be back on tomorrow. All right, Christian, I wanted to ask you about due process now. Remember talking to you, and once again you had told me that, an individual or person has the right to be heard. And the reason why I'm asking you this is because I was speaking with a gentleman, and he gave me a situation where he had a friend that had a collateralized loan also, and what the bank did is somehow got a judgment and bonded the sheriff to come, pick the vehicle up or take the trustee to jail, or, the whole process of how that works. So I wanted to know, in the event of something like that, what would be the way of relief in order for that? Like, is there a violation of due process in that type of situation because there was no hearing? And I would think that it would be like that across the board, but he said in his state the way it happened, that's the way it went. So just wanted to know, is there any kind of backdoor trickery that can be done to keep you from getting a hearing?
Yes. Under the at-law side, all they have to do is, if they can't serve you, they just send it to your last known address, and if you don't respond, then you're going to lose by default. But that's at the at-law side. But now you got the equity side, which is the other side of the law, which says that constitutionally you were never notified under constitutional requirements because they don't have any signed signatures that you had actual notice. So under the public realm, you can be, thrown in jail, but under the substantive side, under constitutional rights, you weren't given due process. So it just depends what law you choose and which one you can defend.
Right. See, that's what I was about to ask you about, because if it's dealing with constitutional rights, although it has provisions and protections for notification and due process, like, I would rather be in equity. So what would be the equitable relief for a situation like that?
Well, you had a constitutional right that you had been given actual notice, not a gutter delivery or a newspaper delivery, you may never have gotten notice. In fact, you probably didn't. But under the public realm, under statutes and codes, that's good enough in their realm, and that'll get you arrested.
Yeah, definitely. Well, what I planned on doing today, because I thought about that, it had me thinking. So today what I did was I went and opened a street address, P.O. box with an address on it, not just, P.O. box out of the post office. And I got it today, had it set up, and I'm going to actually, draft the actual and constructive notice, tonight after the call to notify the bank of my quote-unquote new address. And, I'm going to create the records of the delivery of them getting that just so they wouldn't be able to do something like that and say because I'm not at my last known address myself personally, you know what I mean? And I just want to make sure that I have record that they have an address on file. My last known address is the one that I'm going to get them tomorrow.
Right. Yeah, if you notified them, then they couldn't serve the last
so
place.
That would block them from trying some type of, trickery like that and sending it to a place that I'm not at no more, nor that I no longer live, and then they get me by some type of default. And I was also advised, which I thought was a good idea, because it's a similar situation from what the gentleman was telling me to what I'm going to be experiencing now. I figured that it would be beneficial to do that. Now, next thing would be so besides all of that, you answered my question about that. So I'm just going to give them notification of my new address. So anything that they're going to send to me, I'm going to make sure that I get notice of it. So if that is the case, they would still be able to do whatever they want to do. But anyway, it's neither here or there. After that now, I'm going to send them notice tomorrow. After that, I wanted to ask you about the process as far as, the discovery, show cause, and I got some information on there, but from listening, it seems as if there's a couple of different things that you might be able to do. There's like no set order, and I just wanted to get some clarification on that. Like, what would come first, like a discovery hearing or some type of a show cause? Because I know these are pre-trial events.
Are you just going to do a show cause, you mean, pertaining to just a show cause hearing?
Yeah, like, I guess what would happen if a foreclosure proceeding was to have started already, and either you're going to be coming in as the third-party plaintiff under trust, or you're going to be the original plaintiff. Is either, like for me, I take them or they take me. If they take me, either way, I'm turning that around and coming in as a beneficiary third-party plaintiff. Now, in that event, I know there has to be some type of hearing first.
Well, if they came at you, you would be in a trial already, and there wouldn't be any need for you to come and set up, a show cause. The show cause would be me coming at them, and I would take just the short route, so to speak, and just do a show cause as to why they should not be held up in breach of trust. Okay. And that wouldn't be a full-blown case, the whole pleading, that would be the... So if you lost there, you couldn't fall back on the pleading on a main case. That's no problem.
Okay, all right. Okay, so that's better clarification. If it was a show cause hearing, then that would be me taking them to court. And I remember you spoke to me about that before on another call, that if you lose in a show cause hearing, you wouldn't be able to fall back on your bill or your pleading, and that's it right there.
Yep, right.
Okay, so then that means if it's a prerequisite for you to come in as, primary plaintiff, if it's a prerequisite to have a show cause hearing, then it's kind of iffy. You would have to know how to work the proceedings of a show cause hearing and get your case taken care of right then and there. under trust now. So
yeah,
would that mean that it would be
any case, but you're only got one shot at the apple there, so.
Yeah, exactly. So then in certain ways it would be better or been more beneficial in certain ways to wait for the proceeding to be started against you first?
Well, I think we might have talked about this
before.
Earlier, a month ago, it was like I would have said that it would be better for you to come in with a counterclaim. If they were taking you to court, come in with a counterclaim, and I would say that would have been a more powerful position at that time. But now, knowing what I know now, it makes no difference. I could come at them with a claim, or they could come at me with a claim, and I'll come in with a counterclaim. And counterclaim or claim, me coming at them makes no difference which one. I can see now there's no real difference.
Okay, then. So I guess at a show cause hearing, all right, then. So
let's say there's no advantage. No advantage. Let's put it that way.
Okay. So then that would mean, as a primary plaintiff, one of the prerequisites, like I said, would be a show cause hearing, but that at that show cause hearing, you would establish the fact that there is no remedy at law and we have to go to equity with this. That would be the place to get it done then, right?
At a show cause hearing or?
At a show cause hearing, because like you said, if you're coming in as a primary plaintiff, you're bringing the action or the suit against them, you would have to show, you said you would have to do a show cause hearing to show why you want to bring suit against these people, whoever they may be, correct?
Yeah, well, there's two ways to bring a claim against them. One would be just the short version, the show cause hearing, or the full-blown case, with the whole thing when you got a petition and all that stuff, so.
Okay, all right, okay. So it's not a prerequisite, it's either or. I can do the shortcut and just do a show cause hearing, and if I know how to work the proceedings of a show cause hearing, I can get it taken care of there. But if not that, then I would be able to just do a complete bill and a full trial, and we take care of it like that. So those are the two options as primary plaintiff, right?
Right.
See? That's what I'm talking about. I needed that. See, that changes things for me now as far as my way of thinking, as far as how I was going about things. I mean, documentation is still the same, but I know I have a better understanding of my options because the trust is very powerful. And
a full-blown case, you got everything available to you. You got discovery and all that other stuff, and you got many options that you could go by. But this just the mini version of the show cause hearing say, you're going in there you better be going in there with a scalpel and knowing what you're doing. So, because you got no second chance.
Yes, exactly. Great analogy. Great analogy. You got one shot to do it right. Okay, so, I guess I would just have to know, exactly what happens inside of a show cause hearing and how to operate inside of there to be able to, do things right before first time proof.
If we knew more about equity and how I predict it's going to be, and we had those results, I don't think anybody would be too much more scared to go the short route because they understand how equity is working, because I think everybody's hesitant about it because they all brainwashed according to the at-law side and they have no experiences at equity.
Yeah. Well, I'll tell you one thing. Although there is much more to be learned and gleaned from equity, as far as CJS and American Jurisprudence and the plethora of other books that's out there about trust, I believe, in my personal opinion, that we have more than what we need to get relief because there's certain rules, there's certain maxims that they have to abide by, and like we've learned, when you're in equity, there is a different ball game going on that we're playing, and I know there's intricacies to it, but I really do believe that NCT has more than just the foundations to make it work. It's just the implementation. And, you know, recently we've been seeing the small successes that have been coming through the process of merging titles and the whole, you know, moving titles platform. So, like, I have those same expectations also. That's why it's like an adventure, just finding out new stuff all the time, and just the more we read, the more information we get. But that's what I wanted to actually talk to you about, and you cleared up a lot of things for me tonight.
Like what I read last night?
Say that again?
Like what I read last night on the enforcement of the trust?
Yeah.
Did you hear last night's?
Yes, I was there. I listened to last night, definitely. I was there.
Yeah, well, the enforcement of the trust.
We were on the call okay.
Yeah, and then couple that with a study of the equitable maxims in equity. We need to study the equity maxims. And you can do just a Wikipedia search for equitable maxims, and you'll take you to a site there that is pretty good, just for a condensed.
I actually have it.
And it explains those maxims. And if you sit there and dissect those maxims, and you know those maxims like the back of your hand, I think that's all we need to know.
Yes. I actually have that same information that you have, because I did go to Wikipedia and look up maxims, and, you know, I copy and paste everything and put it inside of a Word document. I have a folder with just equitable maxims, and which leads me to another question. Now,
I'm going to go over those maxims one of these days. So one of these days shortly. So because I think we need to go over.
Yeah, that'll be great. Yeah, that'll be great, because I actually go over them frequently myself, to tell you the truth. And now, there's been a question, like I said, I've been going over them for a while now, but there's been a question that I've been wanting to ask you. Like, we have books and, you know, documentation that date back to the 1800s, and you say that we can't use clean hands. It's a doctrine. It's an at-law remedy instead of an equitable relief. But even from these books dating back 100 some odd years ago and more, it says that the clean hands doctrine is an equitable maxim, and that's kind of confusing to me.
Yeah, because, well, if it's pre-33, it's a maxim. If it's post-33, it's a statute and code with a look-alike of the real equitable one held in chambers.
Okay, so it is a maxim, but that maxim applies in private equity.
No, it's like, okay, they have the doctrine of unclean hands pre-1933, which is an equitable maxim, period. Now you've got the doctrine of unclean hands, which is a statutes and codes equivalent post-1933. And then you've got a in chambers equivalent, again, of the doctrine by the maximum of unclean hands. So it's like they've dueled it. Do you want the statute and code version, or do you want the equitable one?
So would one not be able to specify which one you're talking about in your law form? I guess in your indenture, because if you're talking...
You'd have to set the switch, yeah. You'd have to invoke the one you want. And I wouldn't pick the one that's the statutory one.
Okay, see now, that again clears things up for me, because it was always confusing to me. Like I said, I read in these books, 1920, 1847...
If we have something that we're claiming that's pre-1933, remember, that perfect something, a trust came in and split it in half. And now there's two versions of it. One's the real one that's in equity, and the other one's the statutory equivalent look-alike that you don't want. One's the legal title, one's the beneficial title. Beneficial title being the one of substance, so the real man, the legal title being the one that's look-alike under statutory.
Right. Sounds good to me.
So it might not always
so,
but that would be the rule that I would go by, because post 33 and pre 33, there's a big difference. There may be lookalikes, but are they the real thing?
So we just make sure that we express our law form in the indenture, and that takes care of that. So then we would be able to say, cite or quote that doctrine of clean hands or the clean hands doctrine, because it's post 33 in our indentures.
Yeah, I just have to make sure that we're invoking the right thing.
Yeah, okay, cool. Well, you've always taught us that's a maxim itself for NTT. You must express your law form. So that's easy right there to figure that out. It's just good to bring it in like that. So,
yeah, if you don't express equity, it's at law general by default.
Right. Exactly. That's NTT all the way. Express your law form, you're expressing a trust. Now, okay, so you said the two things that you would really recommend that everybody pay specific attention to is to dissect the maxims in equity. I think altogether it's like 12 or 13 of them that I've seen. I've seen actually a couple more. I've seen some like more modern versions that were not stated in the earlier version, say from 80 or 90 years ago or whatever the case may be. But so you say study the maxims,
not
know them like the back of our hand.
Yeah, not all maxims are equitable maxims. There are common law maxims out there.
Right.
Which again,
different
law forms. So.
Yeah, well, when I've done the search on equitable maxims, I would see probably one or two more that would not be in, say, a PDF file that we have, that you would get off of Google Books or something from, early 1900s or something like that. But so it would be that, and then the next thing would be administering the trust, not enforcing, administering the trust. And it's funny because most of Gilbert's is like the trustee's duties and the administration of the trust. So those would be the two things that you would really suggest we start paying close attention to.
Yeah, once we got a trust, we better learn how to administer it, or we'll be in breach of ourselves.
That's right. Okay. So then there it goes. So now, all right. So after that, it would mean then we would also have to learn, which obviously I'm going through right now, learning the colorable side also to be able to balance it and equilibrate it the right way or correctly, because you have to go through the at-law side to get into equity. They're not just going to let you in there just that easy, unless it's a, specific or certain circumstance. So I would believe that would be the third thing also, or, doing it in between as you're juggling both back and forth between trust, administering the trust and the maxims, because we need to learn how to also apply this in the public through our notices and our NOIs, and knowing what it takes to practice procedure in the form in the public, and know what you're doing with that in order to get into equity, because, that yellow brick road is just not paved out for us to walk on unless we know it exists. It's like a secret. So, all right, I think that's it for me tonight. Once again, Christian, I appreciate it, and you answered a lot of questions for me, and I have a better understanding of my options and some more direction as far as where I need to go with my studies.
Okay. Well, be wise as a snake and gentle as a dove.
Right. Well, right now, when I went to the law library, I photocopied almost 200 pages of injunctions from out of CJS, and I really want to get through this first and really learn about these injunctions and, the parts that are specific that I that I need right now, and then jumping into those maxims right after that. So, like I said, once again, I appreciate it, and I'll be talking to you soon, Christian. Thank you.
Okay. Thanks, Marshall.
Thanks, Marshall. Next caller is from
All right, I appreciate it.
All right. Have a great evening. Next caller is from East Virginia. Go ahead, you've been unmuted.
Hi, Christian. This is Floyd.
Hey, Floyd.
Hi. I want to have something cleared up on tenure. When we're talking tenure, are we talking pre-1933 or post-1933? Is that what we are talking about in tenure?
And tenure's time. I don't know whether you're applying pre or post. It's up to you.
Yeah, well, yeah, but that's what I want to clear up, and because I'm talking post or pre 1933 when I'm talking equity. That's what I'm talking as far as I'm concerned but I wanted to make sure that was the tenure that we're referring to when we say tenure.
Well, say on the public side, yeah, it would be the post-33. If I'm going to be playing in equity, it would be pre-33.
Right, okay. Now, there is a question that I have on the public side. If you're the defendant in the case, and you're putting in your trust material, it's not as important to put in a cover sheet or something like that looks like it's in Admiralty, is it?
No. Admiralty is public.
Yes, right.
Admiralty is commerce.
Right, exactly. So you don't have to put anything. So they're dragging you into court, and you're going for your relief in equity. So you're just keeping everything private from the get-go.
With enough colorable, with enough of a colorable pleading to come into the case and not traverse and argue the facts, but just to get into in camera. Exactly.
Yeah. Right. Okay. Well, I was trying to help somebody out, and she has her case tomorrow, and she was all shook up and rattled about looking like she was coming into Admiralty and staying in trust, and I've been trying to get her to understand. If all she does is put her information in, her trust information into the court. She puts it in through the clerk, and then they stamp it and gives it to the judge or whatever, and then that's what the judge holds. And then she doesn't bring that out into the public at all. She just says, those five things that fellow said the other day.
Now, this is
right. Yeah.
1, my name is so-and-so, grantor beneficiary. 2, this hearing is contrary to equity. And 3, trust is special matter. And 4, as there exists no adequate remedy at law. And 5, I invoke the private side of equity for relief.
Exactly. I told her to stick to that, and she'll be just fine. And because tomorrow is when the judge will say, okay, we got a reset here, or whatever he's going to say, or give me a call and we'll go into camera.
The nature of her hearing?
I guess it's a foreclosure. They foreclosed on her house, and she's I guess they're ready to move her out or something. I don't know.
What's the action for the hearing?
What is the maximum for the hearing?
What is the cause of action of the hearing?
Oh, the cause of action. I'm really not quite sure. I just...
Is it an unlawful detainer action?
Yeah, I think so, yeah. Probably something like that.
Well,
yeah, it must be because that was the one that Carlos was told her to put in a renter, that she has a renter in her house.
Yeah, it sounds like it, yeah.
So...
House has already been sold, right?
Pardon me?
House has already been sold, right?
I'm not sure if it's already been sold or if it's ready to be sold, but it's real close to the end of whatever it is that they're doing, and I don't know that much about it.
Well, it kind of makes a difference, unless you know what the cause of action is or what type of hearing this is. It's going to be like black and white, which way you play it.
Yeah. Well, I told her to get a hold of Jeff because he knows he had her send her information over to him. So I told her to get a hold of him, and I think that those just telling or just expressing trust is going to stop it, because that's really where it's at. So anyway, that's what I told her to do.
Okay.
But yeah, I just wanted to have that tenure part cleared up, because I know that when we write out our trust or our indenture, that we put the law form in as 1776. So that's obviously what we're talking about then is pre-1933 for the equity. So anyway, that was all I had. Okay. Thank you, Christian.
Thanks, Floyd.
You're welcome.
Well, that's all we have for callers tonight, Christian. So let's go ahead and wrap it up for the night, and we'll reconvene next Wednesday night, 8 o'clock Eastern time.
Thanks, everyone. Thanks, Matt.
Yep. Thanks, guys. Thanks, Christian. It's always a pleasure. You guys have a great week, and we'll talk to you next week. God bless everyone. Good night.